gentleman from Maryland is recognized.
Thank you, Mr. Speaker. I appreciate, of course, the temptation to just change the subject and talk about something completely different because there are no arguments left on their side. The D.C. Circuit Court of Appeals, in the Trump versus Benny Thompson case, in an opinion of more than 50 pages, reviewed all of the arguments on both sides about executive privilege and said executive privilege is a claim which, of course, belongs primarily and principally to the existing president of the United States, not to a former president of the United States. To the extent that a former president of the United States can raise it, the presumption is that the people in our constitutional democracy have a right to all of the information they seek in order to govern ourselves. That's what the investigative power of Congress is about. We've got the right to obtain the information we need in order to legislate. So the presumption is we get it. That can only be overcome if a sitting president, or in perhaps some exceptional cases, a former president, demonstrate there's some compelling need that would override the fundamental right of the people to get the information we want. And the D.C. Circuit panel found unanimously that not only had they not shown there was a compelling need on Donald Trump's team, they didn't even identify a potentially compelling need. And of course, there isn't one. Why? The Supreme Court has already found that executive privilege does not cover criminal activity, much less could executive privilege cover insurrectionary activity or activity designed to promote an insurrection or a coup against the United States of America. So I welcome my colleagues talking about anything else because it simply demonstrates their abandonment of the executive privilege argument, an argument also that's been abandoned by Mr. Meadows himself, who voluntarily turned over 9,000 pages worth of documents to our committee, thereby saying there was no privilege at all. But now he's refusing to testify about it, apparently because of Donald Trump's explosive reaction to the publication of Mark Meadows' book. I'm sorry, that is not a constitutional defense to being called to testify before Congress. You can't say a former president is mad at me and wants to wave a magic wand so I don't have to testify. That doesn't work in our system of government. Mr. Meadows must come and testify like hundreds of people come to testify before our committee about this brutal attack on our system of government. I'm going to yield at this point 3 minutes to the gentlelady from Texas, Ms. Jackson Lee.